James.
Thank you very much, Kadim Mustafa. You're aware from Mr. Richards' presentation about the complex landscape within which family businesses operate. They're that much more complex, nuanced, and potentially enriching or diverting in equal measure, potentially, with all the different stakeholders. You've also got the overlap of interest that he outlined of the shareholders themselves and the family members being one and the same. Only I am seeing the screens, so I'll start with this lovely image of children. And I would suggest that without a bespoke strategy and suitable conflict management process, the managing and maximizing of a family member's performance can be challenging, and that which makes family businesses so special, so permanent, flexible, agile, and so forth, can be undermined if there is not a process that Mr. Richard alluded to, not just for succession planning, but the managing of performance of staff, the managing and promotion of family members versus non-family members, and all that that entails. You could even end up in a situation where a senior manager of a family business or government could criticize a family member, and that family member simply says, "I'm the first daughter," in which case they would trump whatever was at issue. In terms of Deloitte's themselves, they've actually done a number of studies of business, as have most of the large accounting firms. And they point to the core issues of dispute among families being the lack of the succession planning, the divorce, the death, and so on that Richard mentioned, and also but also intra-family disputes. There's a big problem with this because when you've got these disputes, you have to remember that risk-taking and business value are linked. And if the family becomes risk-averse or somehow inhibited or loses its agility, this can undermine not only its viability and profitability, but also have other impacts on recruitment and retention of senior management. In terms of risk management, resilience, and ADR, there are different perceptions between traditional businesses that are family-run and more recent ones that are more corporate in structure. And one of the exceptions to the rule is that, for example, uncertainty of economic outlook and geopolitical uncertainty, according to the Deloitte's study, pointed out that in non-family private member committees, you've got the question, sorry, I'm not clicking this, I'm only clicking mine. The risk management issue is that for non-family private companies, they have in the top 5 the question of economic uncertainty and geopolitical uncertainty, whereas with families, that is completely absent. And the reason they give for this is that family businesses are usually more agile in terms of through turbulent times because they take a longer term vision, they take a longer term horizon view. They also have more secure financial structures. And lastly, they can make quick decisions because they have this unity. The issue is going to be, of course, if they don't have this unity and what happens. Now, I would refer to George Bernard Shaw when he said the greatest problem in communication is the illusion that it has taken place. Now, he's obviously only half joking when he said this, because people can be saying things and not hearing one another or not listening at all. Nothing says "I love you, Dad," for example, as "see you in court." I attribute this to the famed SCCA speaker speaking right after lunch today. I think we've all known people who run very successful family enterprises and people who have not had such good fortune at some point. The case study I would like to point to is actually in Global Arbitration Review, which is the preeminent arbitration trade journal, and their editor, Alison Ross, is here for the conference if you'd like to chat with her and discuss a lot of their editorial content and membership, of course, and accessing their services. The case study in question had the less than appealing for the family in question headline of "English Court Restrains Lebanese Arbitration of Family Feud." The word feud, of course, is pretty loaded, especially in this region and internationally. Here are the simple facts. A New York-based only daughter of a Palestinian businessman who, together with his cousin, founded SCCA Group in 1950. Virtually everyone in the room knows of this firm, which is now worth over $5 billion US. The claimant commenced litigation in the English Commercial Court in 2013 against defendants, including 3 sons, who were her cousins, her 2 brothers, and CGC, the parent company. Interesting, this word parent. The claimant alleged that they had conspired to misappropriate her father's assets and deprived her of her entitlement to shares. And of course, her father subsequently passed away intestate, another challenge in itself, in 2010, and 8 years after suffering a stroke, which had severely inhibited his performance, and many would suggested totally incapacitated. Soon after she had filed her lawsuit, her brothers, together with their company, CGC, commenced ad hoc mediation, and I can hear the institutional providers in the room saying their first mistake. But it was an ad hoc mediation, and presumably a perfectly good one, against the claimant in Lebanon. Now, this occurred under the dispute resolution clause in CGC's Articles of Association. They sought a determination as to their and Ms. Sana's entitlement to the shares of CGC in any sums that were owed in the shareholders' account. Now, unfortunately for the parties, the Court of Appeal of England and Wales found that Sana's claims were not based on CGC's Articles of Association, but on general Lebanese law, and that she was not bound by the agreement to arbitrate. It also held that her claims fell outside the very scope of the agreement itself, and she was expressly limited, which had been expressly limited to 2 categories of dispute. Even the UK Supreme Court rejected the request for permission to appeal that decision in March of that year. This is a perfectly good example of many things. One of them is one has to be very careful when drafting an arbitration and disputes clause to ensure that it covers any and all disputes arising, although this is probably a little outside that even for what could have been anticipated originally. But also I would suggest that they should have considered the option of actually mediating, as Mr. Richard and others have suggested in their presentations, because mediation would have allowed the parties to have dealt with a very complex family situation with disparate family members, different generations, they're resident and domiciled around the world, they have corporate entities all over. She was able to bring an action in the UK because one of them was resident in the UK, and she was able to proceed in that route. The arbitration itself went all the way to an award, and the successful prevailing party sought to have this thing set aside because they felt that they had gone all the way to the end. They actually had an award in hand. Why not let this play out? But the judge in the UK, Justice Knowles first and then subsequently in the appellate courts, decided otherwise. They felt that it was reasonable given that this should not have taken place and they were applying the law appropriately. If they had mediated this dispute in an ideal situation, they could have narrowed the scope of the issues. They could have narrowed options, potentially reached some sort of consensus on a number of issues, and then if there was anything remaining, like evaluation of the shares, the business, or sharing of studies, or simply having an independent finder of fact or an arbitrator, it would have worked. Instead, one party went straight to ad hoc, and then they found out that it wasn't optimal. So I would submit that all the counsel here and all the capable people involved in running family businesses, and one of my learned friends and board members of SCCA, Sheikh Yusuf, among them, that they would all consider using a step clause, so that they would consider first approaching this from a mediated standpoint and then an arbitrated process in order to contain things. I don't think the families were particularly happy that their family name and reputations and so forth became a punchline in an arbitration trade journal, and I welcome your questions.
Thank you so much, James.